Hi everybody, this is Alan from Alpus Group, and I'm going to talk to you today about navigating the legal issues in property buying. Buying a property can be an exciting but a complex process, and it's crucial to understand the legal implications involved. So here's a quick breakdown of some of the key legal issues to consider. Firstly, contracts and agreements, offer and acceptance. When you make an offer on a property, it's essentially an offer to enter into a contract. And once the seller accepts, a legally binding contract agreement is formed. So you can hedge your bets with this under English law by saying that your offer is subject to contract. There are different laws that apply in Scotland, but essentially, if you're unsure about the condition of a property, or you have reservations about certain aspects and you need more information, such as a survey, you can say you make the offer subject to survey or subject to survey and contract. So you're making a conditional offer, and you can also, in other circumstances, make an offer that is subject to contract, subject to survey, and also subject to planning permission, because you don't want to commit yourself to an offer of a high amount of money if you don't get the planning permission that you need to get the value from the site that you're offering on. So that's offer and acceptance. So essentially, you should, if you're a property investor, qualify your offer if you're not sure about something. You can make the offer, but just make sure that you qualify it in writing and say subject to contract, or subject to survey and contract, subject to planning permission, or subject to all three, subject to contract, survey and planning permission. And then conveyancing, this is the legal process of transferring ownership of the property. So a solicitor or conveyancer will handle the paperwork and ensure the transaction is completed smoothly. So they've got particular expertise in searches, local authority searches to do with the title of the property, and also with land registry as well. So essentially, you need a professional solicitor to carry out the conveyancing of the property that you're undertaking to buy. And then your solicitor will deal with the vendor's solicitor about the transfer of ownership. Now, there may be a lease agreement. If you're buying a leasehold property, then the lease agreement outlines your rights and responsibilities as a tenant. So these are very important as well. And you can purchase a property that is a leasehold agreement, but very often these take longer than normal freehold agreements, because the solicitor, your solicitor, has to deal with not only the vendor solicitor but also the freeholder of the title. And sometimes management companies of flats particularly can make money out of this, so they'll require you to pay what's called a management pack in order to release information. So leasehold properties can be more complex, and I had one recently and it took about 7 months to complete, and this is not unusual. We sold a leasehold property. There was no real problem with it, but just the legal process and the management pack from the management company, various inquiries and searches, took an extraordinary amount of time. So just be careful with leasehold properties. So property rights and restrictions. There's the land title. So when you're buying, you need to ensure that the property has a clear title, meaning that there are no outstanding claims or disputes about the title, and that you're actually buying from the registered owner of the property. You know, if there are two owners of property, for example, a man and wife, you need the consent of both parties to actually buy the title of that site. So just be clear, but your solicitor will cover this sort of thing. Covenants, these are restrictions or obligations placed on the property by a previous owner or a developer, and they can affect what you can and cannot do with the property. For example, a covenant may exist on a property such that it can't be developed. For example, a certain part of the land can't be developed. So if you've got such a covenant, on land, then you're obliged to comply with it. You can't then ignore the covenant on the property, or it may preclude certain uses of the property. So your solicitor again will draw these to your attention, but you need to be very aware that properties are not necessarily unrestrictive in the covenants that they have on them. You know, there may be a covenant that applies on a certain property. And easements are rights granted to someone else to use part of the property. For example, a right of way, or for example, a right of access to a substation, or a right of access for maintenance for a gas pipeline or a water pipeline. These are all things that may affect your ability to develop a particular property. Thirdly, financing and mortgages. Mortgage contracts, you need to understand the term and conditions of your mortgage agreement, including the interest rates, the repayment terms, and any penalties that apply for early repayment. So this is fairly clear. You just need to conform with the conditions, and your mortgage may have certain restrictions on it. For example, if you take a leasehold property, it may preclude the use of short-term rentals in that property. And if you do short-term rentals and you've got, for example, a buy-to-let mortgage on a property that you're using for short-term rentals, you may be in breach of the conditions of your mortgage. And if you, for example, have a fire at the property, it may mean that your insurance terms are not applicable. So you need to be very careful about complying with the terms of your mortgage. So if you're doing short-term rentals, then a holiday let mortgage may be more appropriate. It may cost you more money, but you need to be sure that you've got a mortgage product that is suitable for the use that you're putting your property to. And then stamp duty, this is a tax payable to the government on the purchase of the property. The amount depends on the property's value and your circumstances and the type of building. For example, residential properties are at one rate and commercial properties are at another rate. And then permitted uses, you can only use the property that you're purchasing for the use that is allowed under its current use under the Town and Country Planning Act. So you can't take a residential building and suddenly start doing a commercial activity from it, like setting up a workshop or carrying out retail sales from a house in a residential area. And equally, you can't set up a noisy workshop in a residential area. So if you want to carry out particular types of activity, you need to check for what planning permission you may require to carry out that activity. So you seek to change the use of the building, you want to make significant changes to the property, you need to submit a planning application to the local council. There are such things as permitted development rights for residential properties, where you can extend properties at the back, provided that you don't interfere with overlooking rights of your neighbours and rights of light for your neighbours. So again, you need to be careful about these things, but you can carry out permitted development rights provided you comply with the strict criteria applying for them. Disputes and legal actions, boundary disputes do occur, and if there's a disagreement about the boundary of the Property Act, it can lead to legal action. So it's best to be clear about what your boundaries are and what your obligations are. For example, to maintain and replace the fencing on a particular boundary with your neighbour. Usually what happens with a residential property, you've got the obligation to repair and replace one side, and then your neighbour has the obligation to repair and replace the other side of your property. So you don't usually have two boundary fences if you're in a row of houses, even if they are detached. You don't usually have an obligation to repair both sides, because your neighbour on one side would have that obligation. Hidden defects, if you discover serious defects in the property after purchase, you may have legal recourse to the surveyor who carried out the survey on the property. So you should really, before buying a property, carry out a survey on it in order to identify what defects the building may have. Professional advice, you need to engage a solicitor or a conveyancer, a legal professional who can guide you through the legal complexities of property buying and protect your interests, and a surveyor, RAS chartered surveyor, who can assess the property's condition and identify any property issues. So by understanding the legal, seeking and taking the professional advice, you can navigate the property buying process with greater confidence and minimize the potential risks. So if you are considering selling a property, then do not hesitate to contact me. That's Alan on Alpus Group, and we're available on 07539 141257 or 0333 224 1257. From overseas, that's +44 7539 141257 or +44 333 224 1257. You can schedule a call with me at calendly.com/AlanJE, or you can drop an email to alan@alpusgroup.com. Cheers for now.